be seated. This Honorable Assembly has resumed its sitting. When we took the suspension, the Honorable Minister of Health had completed his introduction of the bill. The matter is still open. The elected member for Northside.
Yeah. Thank you, Mr. Speaker. Mr. Speaker, I rise to make a short contribution to the debate on this bill before the House, Health Practice Amendment and Validation Bill 2020.
Sorry, that was not your introduction.
Mr. Speaker, I have some very serious concerns about the actions that this bill is intending to authorize and deliver. Mr. Speaker, this bill seems to fix issues, some of which, Mr. Speaker, you will recall I raised when the Health Services Law 2013 was being amended to introduce this, what I called at that time, barn door for institutional registration to be allowed below the standard that Caymanians had to meet. And setting up a separate system of healthcare professionals who could not qualify under the high standards required for Caymanians, which this country had developed over many years, but 39 years to be specific. Mr. Speaker, since I received this bill, I have been contacted by several healthcare professionals expressing their grave concerns about this bill. This included, Mr. Speaker, an invitation to lunch by Health City, whom the minister introduced in his introduction, said that some of these amendments was intended for, which is the only institution that actually has institutional registered healthcare professionals, not just doctors, all healthcare professionals. And remember, what we are doing here today is not just for 8 doctors. This is for all healthcare professionals registered at that institution, whether that is nurses, pharmacists, lab technicians, radiographers, x-ray people, etc. But interestingly, Mr. Speaker, Health City informed me that the only thing in this bill that they asked for was to remove the cap of 6 years on their doctors. And I was quite straightforward with the gentleman. I says, well, you know, I am not going to support that, because that cap was introduced during the debate as part of trying to reduce my argument against institutional professionals, and it was claimed that they would not be working on Caymanians, so it was okay for them not to be licensed to the same high quality that Cayman doctors and people with general registration had to achieve. And that they knew nothing about the other amendments, specifically the clauses for indemnity, etc. But, Mr. Speaker, I'm very concerned about the other clauses. But that subtle little amendment in removing that cap is the most dangerous thing to Caymanian healthcare professionals in this piece of legislation. And I will explain why as we go along. Mr. Speaker, my concern is so great that I have taken the time to prepare and file a number of amendments to the current legislation. And I listened very closely to the minister's contribution to the debate in moving the bill. Unfortunately, nothing in his presentation in any way alleviated any of my anxiety as a non-practicing healthcare professional. Mr. Speaker, I have not encountered a single healthcare professional that supports this piece of legislation. It would be interesting to see if the minister could table recommendations from each of the boards supporting this legislation or requesting that this legislation be drafted in the form that it is. Because they're the people that should be raising the questions. That's what we appoint them for. I believe, and have good reason to believe, that the minister may have received actual written correspondence from the Cayman Islands Medical and Dental Society asking for a number of clarifications on this bill. And I trust that the minister has responded to them in writing, because there are no amendments, nor did he explain in his debate any of their concerns. But, Mr. Speaker, I could add and ask the minister to address these few additional questions in his wind-up debate. They are, number one, how many healthcare professionals does this affect? Is it hundreds? What is the problem this bill is seeking to fix? Is this a problem with the process of registration? Or is this a problem with immigration? Because the minister, in moving the bill, alluded to the fact that somehow their 6 years being on the island had expired before the license. Now, what time you be on the island, what that has to do with your license, befuddles me. Because there's no requirement in the current legislation that if you're not registered, you have to leave the island. Third question, who caused the problem? Is the problem the licensee did not apply for their registration in a timely manner? Or is the problem that the boards somehow missed out a period of time in issuing a license? Is it a failure of the boards, or is it a failure of the licensee? I hope I misunderstood the minister when he said in his presentation that as a result of this legislation, when it comes into effect, all pending lawsuits would have to stop. Because I would remind members that last year, or it might have been the year before, we had to remove indemnity from the HSA physicians. Here we are coming here today now and giving these institutional practitioners indemnity again. Why? Mr. Speaker, let me try and deal with my specific and the specific clauses in the bill. Mr. Speaker, let me speak first to clause 5, which offers an amendment to section 24 of the current law that deals specifically, 24A, sorry, that deals specifically with institutional registration. Now, on the surface, it appears to be a very innocuous change. We're simply saying that they can renew their license every 2 years. And it's a nice way to sneak it in, because the memorandum objects does not address the real problem here. The real problem here is that we introduce institutional registration for these physicians, and we limit it to 6 years. Why? Because the country and the healthcare professionals and the Caymanian healthcare professionals were given the assurance that these people could not progress to PR and Cayman status and keep Caymanians who want to be doctors out of jobs. But that's what this amendment does. Once we remove the 6 years, every healthcare professional who's registered under this particular section of the law will be allowed to renew their license ad infinitum. Remember, under the immigration law, once you get to year 9, you can apply for PR. Are these, especially the top professionals up there, likely to be denied PR? Not likely to be able to get 100 points? Well, if my information on their employment contract and what their remuneration is, it might be extremely difficult. But I'm not asking fellow members what their intentions are. I personally been approached by some of them to find out how they can convert their institutional license to a regular Cayman license. And some of them already have. Because, Mr. Speaker, let me read what the section that is being amended says. The substantive law, 24A, says, in section 4, 24A4 says, registration under this section shall be for a period of 2 years and may be renewed for only 2 consecutive periods of 2 years. And a practitioner wishing to renew his registration shall apply for such renewal not less than 60 days prior to the expiration of the registration. What we are amending the bill to say is registration, and I quote from clause 5(4), registration under this section shall be for an initial period of 2 years and may be renewed for consecutive periods not exceeding 2 years in any period. A registered practitioner on an institution registration list who wishes to renew that registered practitioner's registration shall apply for the renewal not less than 60 days prior to the expiration of the registration. And Mr. Speaker, I can come back to that 60 days further on in my debate. Now, the memorandums and articles to the bill for clause 5 simply says, Clause 5 amends Section 24A of the Principal Law to provide that the registration period for institutional registered practitioners shall be for an initial period of 2 years and may be renewed for consecutive periods not exceeding 2 years in the period. No mention of the fact that we are removing the cap. And these people will be allowed to stay to year 9 and apply for PR. Now, Mr. Speaker, what we going to do with them when they get PR and Cayman status? Are you going to have 2 kinds of Caymanian registered health practitioners? One that meets the very strict and high standards in a general licensee for health practitioners, and one set of Caymanians who are registered as institutional practitioners because they can't meet the qualifications of the ordinary Caymanians. Now, my position, Mr. Speaker, as you will be aware, was that there was no need to do this. I believe that the doctors who were coming to work at that institution would have been quite capable of qualifying to the high standards. But this was a very expedient way to do it. So, Mr. Speaker, once these people get PR and Cayman status, and they would say, well, I'm a Caymanian, I'm registered, I want to be relieved from this institution that I am chained to, and the remunerations, I should be allowed to take part in that remuneration that exists out there for all the Caymanians in the field. So, Mr. Speaker, that troubles me, and I know it troubles a lot of Caymanians. Caymanians who've already qualified with their MBBS, Caymanians who are in medical school, Caymanians who are already working in the industry, Caymanians who wish to specialize, and we put in the budget, the last 2 years, $1 million. We spent less than 25% of it because the time frame given to Caymanians to apply was so short that they couldn't get acceptance on reputable universities and apply for the scholarships. So we're doing nothing to help our Caymanians. Some of these people have been waiting 8, 10 years to get a scholarship to go and get board certification for specialists. But we are accepting licenses from any college that is listed in the Yellow Book. Mr. Speaker, let me now turn to Clause 6 of the bill, which deals with Section 27A of the Health Practice Bill 2017. Mr. President, Mr. Speaker, sorry. I am very, very concerned about this. And I would ask the minister to explain the rationale and what is the importance of changing to somebody's birth date. Because if you can't remember your registration date, you probably won't remember your birth date either. Because, Mr. Speaker, the one person who knows or should know when their health practice license expires is the licensee. But we're changing it to their birthday for institutionally registered persons. Now, Mr. Speaker, the current legislation says that a person must apply for renewal of your health practice license 60 days before it expires. Current legislation even carries penalties because they accept late registration. I think the fee is $100. Are we seriously saying, Mr. Speaker, that our health practice boards are so incompetent, so inept, that they can't renew somebody's license in 60 days? So I get back to my question. Who caused the problem? If they didn't renew their license, knowing the date of its expiry, then they're not licensed. That's their responsibility. It is not the responsibility of the government and the government boards, appointed boards, to remind a person to apply for registration, That's the responsibility of the licensee. It's the responsibility of the government to enforce the law if they don't apply and stop them from practicing if they have not so applied. Somebody must know who these people were. Somebody must know their license was not effective. Why? Why were they not stopped from practicing? So, Mr. Speaker, this is just what my old professor used to refer to as wings flapping, no birds flying. This is just another way of somehow trying to cuddle these people who have somehow let their license expire for a period of time. Because, Mr. Speaker, standard practice in government, if you're on a work permit, if your car license expires, anything that you get from government, if you go and apply, even planning regulations, if you apply after the fact, the license is simply backdated to cover that period. So why do we have to come here today now? Is this something that happened in 2014, 2015, 2016, 2017, 2018? But it would be the anniversary of 2 years. So it started in 2013, 2015, 2017, or did it happen in 2019? And if it happened in 2019, the simple solution would have been to backdate the license to the date is expired up to the next birthday. So my question is, who caused the problem? Is it the person who was licensed? Or is it the boards who saw the position but did not backdate it to the last license expiry? And why do we have to cover this long period of time? The minister went back to 2002. But the law talks about 1st of July 2013 until this law comes into effect. That could be 6 years from now. Because you know, standards of public health law not brought into effect yet. There's no guarantee that it's going to come into effect this year. Because it has, I'm pretty sure they got a clause in here brought in by notice of the Gazette by Cabinet, which is standard in government legislation. Wow, they forgot that in this one. So I guess it'll come into effect then when the governor signs, what's the vellum copy is called? Right, okay. You don't know. But so, Mr. Speaker, one of the amendments that I have filed is to delete clause 7. Now, Mr. Speaker, I know the government doesn't agree with me on these kinds of governance situations. But as the minister explained in his moving of the bill, the CMO is a new position in the ministry to advise the ministry and cabinet on healthcare policies, etc., etc. So why are you putting them on the board? Giving the man 2 bots. His role, by the way I see it, my opinion, should be to, if the minister gets advice or a proposal from one of these boards, to evaluate the proposal and give the ministry and therefore cabinet the best possible advice on the proposal. If you're part of the board that made the proposal, how are you going to give the man advice? You're putting him there so he can take things that he wants done, cajole the board into getting it done, and then come and advise the minister to do it. The commission is working fine. And good governance requires that this CMO not be put on the board where he can have 2 bots. There's no necessity to put in there. If the Health Practice Commission was non-functional, wasn't doing its job, I might see one to make some changes to it. But to the best of my knowledge, the Health Practice Commission board is working very well as set up under the existing Schedule 1. So why do you want to tamper just for aggrandizement of the CMO? Because make no mistake, when the CMO sits on that board, he is king. Everybody on that board is going to look to him for advice and guidance. Otherwise, why would he be on the board? They're going to defer to him. We take a very strong health facility owner or a health practicing physician to oppose something that the CMO suggests. And we all know it ain't gonna happen. So, Mr. Speaker, I filed an amendment to delete Section 7, and as a consequence of that, delete Section 4, because there'll be no need to define Chief Medical Officer. Because that's a position, that has been fraught with all sorts of difficulties, going way back to the 1970s. So, Mr. President, Mr. Speaker, I cannot support putting the Chief Medical Officer on the Health Practice Board. The next thing is I want to be on the Doctor's Registration Board, the Pharmacist Registration Board, the Nurses and Midwifery Board. Because any justification that you can give for putting them on this board will apply to putting them on all them other boards. And I would have the same reason to object to him going on those boards as I'm objecting to him going on this board. It's bad governance. It is bad governance. The minister has no opportunity, no possibility of getting genuine advice from the CMO if he's sitting on a board that proposes a policy. But he go back to the next board meeting. Sorry, fellas, I agreed with you all here, but I had to advise the governor, the minister, not to do it. Doesn't make any sense. Now, Mr. Speaker, let's turn to Clause 8, validation of the regulations. Now, Mr. Speaker, I'm not a lawyer, but my general knowledge tells me that how are you going to go back to a law that was replaced in 2013 by the 2013 revision of the 2005 law, when you're going back to 2005 law, right? But we actually have a 2017 revision. So we have two laws since the 2005, but we're going all the way back in retroactive legislation to 2005. Why? Does this mean that a new minister coming in to government in 2021 can go back to 2005 and say institutional registrations did not exist in 2005, therefore they're null and void, and everybody who sold license, the license is cancelled? We're setting the precedent here. Whatever legal justification, and my understanding, Mr. Speaker, is that when we have a revision of a law, it replaces the old law that was revised. When you go to the office out here and ask for the health services law, they give you all amendments with it. 2013 regulations not there, I had to get the staff to research the archives to find the 2013 regulations because they've been replaced by the 2018 regulations. Seems kind of funny to me, Mr. Speaker. So, Mr. Speaker, I've also tabled an amendment to delete Clause 8. Because, Mr. Speaker, I cannot understand nor appreciate why we need to go back to 2005 legislation, which has been replaced twice, 2013. Remember, the 2013 revision was done before 2013 regulations for institutional regulation was passed, That regulation, as I recall, was not, that amendment was not the 2005 law. That amendment was to the 2013 law. If you go back to the 2005 law, why did not amendment say this amendment is amending the 2013 revision and the 2005 law and the 2002 original law? Because it was necessary. 2005 law no longer existed. Now, Mr. Speaker, let's deal with this Clause 9. Immunity from suit. Notwithstanding any law to the contrary, no legal proceedings or other action of any kind shall be commenced or continued against any person in respect or in consequence of an act, decision, omission, or proceeding of an institutional registered practitioner done, taking, made, or conducted during a specific period. If the act, decision, omission, or proceeding would have been lawful and valid had the practicing license been issued in accordance with the Health Practice Law 2005, you couldn't issue the license in accordance with 2005 because the 2005 law didn't exist when it was done. It was 2013 revision. be any amendment to the health practice law prior to the commencement of this amending and validation law. But Mr. Speaker, the concerning words in this, of any kind, not just because the person wasn't registered now, which is what we supposedly are seeking to correct. Big question is, what else lies behind this? What else is the indemnity intend to cover? Because if it only covered the lapse in the registration period, it should say that. It says, of any kind shall be commenced or continued against any person. Are there some lawsuits pending or filed that we need to shut down? I don't know. But I'm asking the question. Have there been any letters exchanged serving notice of intending to sue for any kind of malpractice? Section 2 pretends to redeem that, but it doesn't. Section 2 says, for the purpose of subsection 1, any act, decision, or omission of an institutional registered practitioner done, taking, made, or conducted during a specific period is not lawful or valid if the act, decision, or omission was negligent or done in bad faith. So, if one of these institutional practitioners kills somebody through negligence, can't sue them. If we have a case of iatrogenesis, can't sue them. Why? Why do we have to be so broad and so draconian in this bill? I don't support looking after these people who, by their own volition, by their own decision, by their own action, have been practicing medicine for a period for which they had no license. That's their responsibility. If this is such a good thing, why aren't we offering it to all general practitioners? Or can the rest of them now?
Mr. Chair, Mr. Speaker, just a second.
Honorable Attorney General,
Just a
remember
point
you
of
give way, please.
Elucidation, yeah. Mr. Speaker, the honorable member just read a clause in the bill and I think completely misunderstood. Unfortunately misunderstood what it says. And then made the point that if you kill somebody, you can be sued. Which is an unfortunate utterance.
Really?
It says quite the opposite, Mr. Speaker. Quite the opposite. What it means is that if you, as a doctor, during this period, acted in a way that was negligent and or was motivated by bad faith, then this provision doesn't cover you. You're still liable to be sued. Quite the opposite of what he says. So I think normally I would wait until my turn, but I think I just need to clarify that at this stage.
Honorable Minister, I think Honorable elected member for Borden, so North Side.
Mr. Speaker, I hear the Attorney General. Maybe he was shocked because I said he killed somebody, but it happens. It happens. It happens. They're not perfect. And if it was iatrogenesis, but let's say that they removed one kidney unnecessarily. Right? Didn't kill him. They just removed one kidney. Wasn't negligent, it was just an accident. He was trying to get his appendix. He had the knife, he had the scalpel in the wrong hand, and he sliced the kidney open, so he had to take it out. But the person then has iatrogenics, introduced kidney failure, because he has high cholesterol and all these other things, and high blood pressure and all these other things. One kidney can't handle it. So we can't sue him. We just had to do this for the HSA. And my question is, if this is such a good thing, why are we limiting it to institutional practitioners only? Can the rest of the healthcare professionals not working for the HSA because they already covered? If the government forgets to register them, they have a caveat that say not their fault because the government's supposed to register them, so they're covered. But the rest of the Caymanian healthcare professionals out there now decides, well, I can skip a year. After all, the government will come and pass legislation that say because I didn't renew my license in 2020, and they didn't find it out till 2021, right? I can go and say, well, I need you to protect me. It wasn't my fault. I forgot it. Or the board didn't do the work in 60 days. Because I get back to the three questions. What is the problem we're trying to fix? And who caused the problem? So, Mr. Speaker, I have also filed an amendment to delete Clause 9. Mr. Speaker, this whole system of having two parallel healthcare registration standards and processes in the country is fraught with problems. Mr. Speaker, amending bad law don't make bad law good law. Because I can promise you, we'll be back here in 3 or 4 years. Because they now have PR, and they're no longer chained to that institution because they don't need no permission to work. You see, they got two things over them up there now, you know. They hold their work permit, and their registration is subject to working in that institution. And I would say, Mr. Speaker, that some of those who came through that barn door have already gone to Jamaica and set the CAMC exam and are now registered in Cayman and are now working in institutions where they're treating Caymanians, and we were told we didn't need, part of creating this was because it wasn't going to be treating Caymanians, you know. How are we going to address this issue when they become Caymanian? And I said, we're not talking about 8 people, we're talking about hundreds. Because as soon as those who get PR move out into the private sector, they can bring in another throne. And then 9 years later, they're going to bring another group. We should take the time, members, to look around our country. I believe that the advent of that institution, good though it may be, has certainly increased the number of those nationalities working in Cayman and working in all industries throughout Cayman. Because remember, Mr. Speaker, these people don't even have to do an English test, you know. No woman's guilt, each one bring one, Miss Annie say. Right? Remember your gardener? I cut your lawn, got to do an English test. If English is not his first language, these people don't have to do no English test. So, Mr. Speaker, I would encourage the minister to withdraw this bill, because I believe if there's a problem, let us identify the problem and let us try to fix it with as narrow as possible a solution thereto, that specific problem. If it was the government boards who messed up, maybe we simply just need to say in legislation that their license is deemed to have covered that period, you know. We don't need to go through all this about putting the CMO on the board and all this kind of stuff. So, Mr. Speaker, with those few words, I will be voting no against the bill unless my amendments are accepted. Thank you, Mr. Speaker.
Does any other member wish to speak? A member from Newlands?
Thank you, Mr. Speaker. Mr. Speaker, I'm going to be brief because I think that in my contribution to this debate on the Health Practice Amendment and Validation Bill 2020, I think the member from Northside has covered a lot of the ground that I intended to cover. And I have to say, Mr. Speaker, that I am as concerned as he is. Mr. Speaker, certain points in this bill do warrant emphasis. And I was surprised when I saw that we were seeking to, by amending the law, seeking to remove the cap of 6 years on medical practitioners at institutional facilities.
All this is just follow the cover up. Red herrings.
Institutionally registered facilities, because I always understood that the purpose of that cap was to ensure that these individuals did not eventually end up competing with Caymanian practitioners. Now, while they're at their institution, that may not be a huge concern, but by removing this cap, Mr. Speaker, we are increasing the likelihood that they will eventually get permanent residence or Caymanian status in this country. And then they will be out in private practice, or seeking to get out in private practice, where we have a lot of Caymanian doctors. And that is going to, I think, disenfranchise them quite a bit, those Caymanian doctors that we always said we would protect. So I am concerned that we're seeking to make this change. And it seems to me, Mr. Speaker, that we're making this change to appease certain individuals rather than making a change that is for the general good. And that concerns me, because we're not supposed to legislate, Mr. Speaker, for the individuals. We have to be concerned about what is good for everyone. Allowing this change to go through is, in the longer term, going to have that effect. And I quite understand, though, Mr. Speaker, why a lot of our Caymanian doctors are concerned. And I will say, for the record, that I have been contacted by Caymanian doctors who have been extremely concerned about this and other aspects of this bill. I also note that we're going to change the law to allow doctors to continue to work while their application for renewal of their registration is pending with the board. And, Mr. Speaker, while that is, I think, commonplace in other areas, it is taken in context of the fact that we're dealing with doctors, medical practitioners. I don't think that that is good practice, in my opinion. It is actually adding a very liberal sort of element to the registration regime. And we're dealing with medical professionals, Mr. Speaker, who should be registered if they're practicing. And it may just be a formality, but if we want to maintain the very high standards that we've set for this country when it comes to practice of medicine, then we can't make moves now that are going to erode those high standards. If you're a doctor, make sure your registrations are up to date. It's as simple as that. If you forget, I'm sure there's a process where you can go to the authority, the body, and say, I forgot. Can you somehow get my registration up to date if I have to pay an additional fee or whatever it may be? But I don't see why we have to change the law to accommodate those sorts of situations. I mean, it happens with planning applications, Mr. Speaker. People don't apply for planning permission, and later on, they have to, when they're caught or found out, they have to pay an after-the-fact fee, and it's much higher. But there is a way to regularize them. So I don't see why we're stepping out of that mold and trying to find more creative ways of dealing with these things, because it seems to be making things quite a bit more complicated. These are not just regular work permits. These are doctors who have, the primary responsibility to save lives and deal with people's health and well-being. So I don't think we should make steps to become more lax in how we regulate and maintain those high standards, Mr. Speaker. Mr. Speaker, I too have to question and wonder what has prompted this, where the failing was, because we haven't heard that explanation. And I think in knowing where the failure was and hearing the reasons behind it, maybe we could be a bit more constructive in our contribution to this debate and trying to find a solution for it. But we haven't heard if this is the case where the board somehow didn't renew these registrations, or the practitioners themselves didn't do it, or the institution, or whatever failure there was. But we seem to be going sort of tiptoeing around the main issue of what exactly happened. And it would be good for us on this side, Mr. Speaker, to know the full details if we're expected to now support this bill. As it stands now, with the information I have and what I've heard, I can't support it. So, that point, I hope when the minister responds, he will give a bit more detail on exactly what happened. I also have to share the concern with the member from Northside with regard to referring to previous versions of the legislation. And I'm looking at the Health Practice Law 2017 revision, and right on the first page it says, note, not forming part of the law. This revision replaces the 2013 revision, which should now be discarded. And I'm pretty sure the previous version said the same thing. So we're referring to legislation that no longer exists on the books in this bill. And I'm just having difficulty wrapping my head around why we need to do that. Is it that these registrations expired from back in 2013 or so, when the old law was in place? Have they been expired that long? I don't understand the logic behind doing that. Why we're referring to very old, two versions ago, versions of the legislation. But again, maybe, Mr. Speaker, we could get some explanation for that. I have the same concern, Mr. Speaker, when it comes to to 8.2, of the bill, where again it refers way back to the 2005 version of the law, which no longer exists. But Mr. Speaker, I also agree with the member that putting the CMO on the board may not be best practice. It is a ministry role, and yes, I understand you have ex officio roles and members, ex officio members on boards and so forth, but in this capacity, the person who is supposed to be advising the ministry, wearing two hats, sitting in the ministry and then sitting on this board, in my mind creates a conflict that could later on lead to serious issues. I think there has to be some separation between that role and sitting on this board. Mr. Speaker, looking at, and I heard the minister say earlier that ongoing lawsuits, he was referring to Section 9, ongoing lawsuits must be discontinued. Now, Mr. Speaker, I'm familiar with the term sub judice, but if there is an ongoing lawsuit that's been filed in the courts, and we are now making amendments to the law that would force that lawsuit to be abandoned, is that not a cause for concern? Because I understand the context that this was done in, but I am aware that there are lawsuits in court right now. Now, the member said that generally, the minister, and I'm wondering if he could clarify what he meant when he said that, because if it's applied generally across the board, any pending lawsuit in the courts is going to have to be abandoned, then I really can't support what this bill is attempting to do. Now, I'm asking for clarification when the minister winds up so I can understand. But as it stands, that is a serious cause for concern, because I'm aware of some Caymanians who have lawsuits pending. And if this is going to affect that, this is in us interfering with the administration of justice. So I'm asking when the minister winds up that he clarify his statement when he said that, because taken in the context of which he said it, I'm very concerned. So, Mr. Speaker, with those concerns, at this point in time, I cannot support this bill. I will say that I share the concerns of the member from Northside, and I share the concerns of those doctors who have contacted me, and as I said, some of them have been quite animated in their conversations with me, quite vexed at the prospect of what is being done here. And I'm wondering if the minister could also state whether or not we are measuring these changes against what the MOU that we have in place says. Because we do have an MOU, and that has a timeline attached to it of when things are supposed to happen and when things change and so forth. Are we marking the progress made against that MOU? And how do these changes measure up against that MOU? Because again, I would hate to think that we were making changes, Mr. Speaker, in isolation and not taking into consideration that there is an MOU, a business plan, so to speak, that we need to be respectful of. So that again is something that I would like to hear some feedback on. I'm not knocking the institution. There are many people who, Mr. Speaker, believe in the institution and who go there and who get good care. I don't think any of us are doing that. But overall, our greater concern is for the health care and the reputation of this jurisdiction when it comes to health care and the level of care that we offer to locals and tourism, people who come here for medical tourism. Because at the end of the day, it is our name that is out there. that is attached to this, Mr. Speaker, is the Cayman Islands. And so we have to maintain the highest standards. We have to maintain that we're not going to start, for want of a better word, dumbing down some of the requirements to try to fit isolated incidents. We're supposed to be acting for the general good, for the majority, not for select few. So with those few words, Mr. Speaker, I will wait for the minister's response before I fully make up my mind on what my vote will be. But at this point in time, if I don't hear the right answers, I'm going to vote against this bill. Thank you.
Does any other member wish to speak? Does any other member wish to speak? If not, I'll call on the move to, I had already started, move to reply.
Mr. Speaker, could we have a 5-minute break, please?
The House will sit for 5 minutes. Please not to move. That's what we're saying? Yes. Honorable members, we're about to resume. When we took the suspension, I had called on the minister to reply. The Honorable the Minister of Health.
Thank you, Mr. Speaker. Mr. Speaker, I listened to the comments and the contribution from colleagues in the House, members in the House, and I thank them for their contribution. Mr. Speaker, these amendments and validations were brought in good faith, very good faith, Mr. Speaker. And despite all being said, the real focus is to address the registration and the birth dates of the practitioners. This led to people practicing without renewed registration or potentially practicing without renewed registration. This is not a carte blanche attempt to do anything, Mr. Speaker, that is being said in the House. Mr. Speaker, as being said, institutionally registered doctors after 9 years may want to apply for PR. But Mr. Speaker, like everyone else, and according to the immigration law, you can apply for PR, but it doesn't necessarily have to be given to you. Doesn't necessarily mean that you qualify automatically, Mr. Speaker. Mr. Speaker, everyone knows that, and I think it is quite well perceived throughout this whole nation, throughout this whole country, that Health City has made great contribution to this country, and the people of this country have great confidence in Health City. Mr. Speaker. Mr. Speaker, very good results from Health City are being shared all over this country. Mr. Speaker, the argument on the floor of the House about institutionally registered doctors being able to stay here for the full 9 years and be able to apply for PR. Why should the other non-Canadian Caymanian doctors be able to stay here? Why not the institutionally registered doctors have the same benefit? There was a time, Mr. Speaker, when we would question our decision whether we should have allowed this institution or these persons to practice. But I don't think that is the same argument anymore. Health City has proven themselves. They have saved many lives. They have the confidence of the Caymanian people. Things change all the time. And as we progress and as we grow, as been said, there's only two things that can't be changed, and that's a fool and a dead man. And things have changed since inception. So, the Honorable House must also be reminded that this institution that we're talking about is a fully accredited JCI institution. So, Mr. Speaker, this is not the government trying to do something for someone who's just a startup. Mr. Speaker, there's also been mention of why 2005 law is even mentioned. The regulations that created the anomaly was created from the 2005 law. This is the reason for the mention, Mr. Speaker. Mr. Speaker, people become attached to their doctors. How can you deny Caymanians who become attached to their doctors? You must also appreciate these doctors come here and they would perform probably 100 times more surgeries a year than they would do in the Cayman Islands. They risk their careers by coming here and performing less. So we need to be thankful that these doctors even wanted to come to the Cayman Islands. Very, very thankful. That's why even our own HSA, there's certain doctors we only bring in every 2 weeks or once a month or quarterly, because we don't have enough patients to satisfy to keep up their accreditations. So, Mr. Speaker, I have received no information at this time about any pending lawsuits. This government would never knowingly participate in this kind of activity had we known this. So, I don't want anyone in the public to ever think that the government knew something, or that this minister knew something, or the ministry knew something, and that we're trying to protect these institutions from some lawsuit. Mr. Speaker, I will speak further on that. But I want to say that right now in the law, facilities are protected if they are not inspected on time. They can still go on and operate. Likewise, we are trying to do the same for physicians. The councils only meet once a month, and sometimes it has never been known, because I've heard it mentioned in the House about doctors who forgot to register and who forget their birthdays and all kinds of stuff. This has never been the case. The doctors actually apply on time. So at times, sometimes you have situations like after an election where you're trying to scramble and find members to put on boards and different stuff, and sometimes it goes 4 or 5 months before you actually get a board put together. So the problem is not that the licensee didn't apply on time, Mr. Speaker. I also heard some comments about that, how long this would take to be brought in place. It could be another 6 months, or it could be a year in terms of the indemnity. I have no doubt this will be brought into law very quickly, because there are emergent situations pending as we speak. This week, Mr. Speaker, and contrary to the argument about inferring with the existing cases, about the argument about inferring with the existing cases, the sole purpose of the immunity clause is to ensure that these doctors cannot be sued simply because their license had expired when they performed the surgery. Now, however, if their license was expired and they acted in a manner that was negligent or in bad faith, they could still be sued, Mr. Speaker, notwithstanding this clause in the bill. So, Mr. Speaker, for the record, I want to advise this House that there are no doctors at Health City currently with an expired license. I want to make that clear. So it is an emergent situation this week. So, Mr. Speaker, we must also be reminded that there will be a full review of this law. So we can feel some comfort there. I do and there will be a consultative process. Mr. Speaker, I also listened to the member from Northside, and I see the amendments that the member brought, and they have some merit. And I'm going to consider some of these amendments when it comes to committee stages. And So, Mr. Speaker, I hope that some of what I've said, though paraphrased at some points, has brought some slight clarity and comfort to members of this House. And we are going to make some changes at committee stages. Some of what's suggested by some of the members that have submitted amendments. So, Mr. Speaker, I reiterate that this amendment and validation was brought in good faith. It's about trying to ensure that the people of the Cayman Islands receive great tertiary care right here in the Cayman Islands. They don't have to fly out and leave their families behind, and they could be cared for right here on the island. And we need more of this, Mr. Speaker. So, I will thank this Honorable House for their contribution, and I commend this bill to all members, Mr. Speaker.
Question is that a bill shortly entitled the Health Practice Amendment and Validation Bill 2020 be given a second reading. All those in favor, please say aye. Aye. Those against?
No.
The ayes have it.
Speaker, sir, can we have a division, please?
Clerk. Wasn't you the one that kept saying all the while when that lady in East End said, don't involve me in this? Don't do that.
Honourable Alden McLaughlin.
Aye.
Honourable Moses Kirkconnell.
Aye.
Honourable Juliana Connolly.
Aye.
Honourable Dwayne Seymour.
Aye.
Honourable Joseph Hugh.
Aye.
Honourable Tara Rivers. Honourable Roy McTaggart.
Aye.
Captain Eugene Ebanks.
Aye.
Miss Barbara Connolly.
Aye.
Mr. David White.
Aye.
Mr. Austin Harris. No, sorry. Honourable Arden McLean.
No.
Mr. Alva Saku.
No.
Mr. Kenneth Bryan. Mr. Anthony Eden.
No.
Mr. Christopher Saunders.
No.
Mr. Barney Bush. Okay. Mr. Ezra Miller.
No.
The result of the division, 10 ayes, 5 noes, 3 absentees. The bill has been given a second reading. So I repeat, the Health Practice Amendment and Validation Bill 2020 has been given a second reading. The House will now move to committee stage on these bills. Please be seated. The House is now in committee, and with the leave of the House, may I assume that as usual we will authorize the Attorney General to correct minor errors. Which one is the first one? You got amendments to that?
Private Funds Bill 2020, Clause 1, Short Titling Commencement, Clause 2, Interpretation.
Question is that clauses 1 and 2 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clauses 1 and 2 stands part of the bill.
Clause 3, Application.
Honorable Minister.
Thank you, Mr. Chair. In accordance with provisions of Standing Order 52.1 and 2, I, the Honorable Minister of Financial Services and Home Affairs, give notice to move the following amendments to the Private Funds Bill 2020. That the bill be amended in Clause 3 as follows. In Subclause 1, by deleting the words, quote, 2, 3, and 4,
Am I right?
and end quote, and substituting the words, quote, 2 and 3, end quote. And by deleting subclause 3 and substituting the following subclause, quote, 3, where international financial reporting standards or the generally accepted accounting principles of the United States of America, Japan, Switzerland, or a non-high-risk jurisdiction permit consolidated or combined financial account reporting, and a private fund chooses to report consolidated or combined financial statements with an alternative investment vehicle, comma, sections 13, 16, 17, 18, and 19 shall not apply to such alternative investment vehicle, period, end quote.
Minister, you're not taking it any further? You're not speaking to it? No?
No, Mr. Chair.
Question is that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Those against? The amendment stands part of the clause. Question of is that clause 3 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clause 3 as amended stands part of the bill.
Clause 4, compliance with this law.
Question is that clause 4 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clause 4 stands part of the bill.
Clause 5, requirement for registration. There's an amendment.
Honourable Minister.
Thank you, Mr. Chair, that the bill be amended in clause 5.1 by deleting the words, quote, comma, 6 and 7, end quote, and substituting the words, quote, and 6, end quote.
Question is that clause 5 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clause 5 as amended stands part of the clause. Question is now that clause 5 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clause 5 as amended stands part of the bill. Okay.
Clause 6, application to be registered. Clause 7, power to register. Clause 8, risk-based supervision of private fund. Clause 9, name of private fund restricted. Clause 10, private fund to pay annual registration fee. Clause 11, authority to be informed of changes. Clause 12, misrepresentation as a private fund. Clause 13, annual audit of private fund. Clause 14, annual return. Clause 15, retention of records.
Question is that clauses 6 through to 15 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against?
6 to 15?
Yes, I say that. The ayes have it. Clauses 6 to 15 stands part of the bill.
Clause 16, valuation.
Honourable Minister.
Thank you, Mr. Chair, that the bill be amended in clause 16 as follows. In subclause 4B2 by deleting the words, quote, comma, managed, comma, monitored, end quote, and by inserting after subclause 6 the following subclause, quote, 7, the authority may exempt a private fund from the requirements of this section either absolutely or subject to such conditions as the authority may deem appropriate, period, end quote.
That's 16?
Yes, sir.
Question is that clause 16 do stand part of the bill. All those in favor, please say aye. Those against?
The change.
No, there was an amendment.
She did the amendment. The amendment stands part of the bill.
The clause be amended.
Yeah.
The amendments not part of the clause. That's a question. Yeah, the question is amendments are part of the clause.
And that is 16.
Yes, sir.
The question is that the amendment do stand part of the clause. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The amendment stands part of the clause. The question is now that clause 16 as amended do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clause 16 as amended stands now part of the bill.
Clause 17, safekeeping of fund assets.
Honorable Minister.
Thank you, Mr. Chair, that the bill be amended in clause 17(4)(b)(2) by deleting the words, quote, comma, managed, comma, monitored, end quote.
Question is that the amendment do stands part of the clause. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The amendment stands part of the clause. The question is now that clause 17 as amended stands part of the bill. All in favor, please say aye.
Aye.
Those against? The ayes have it. Clause 17 as amended stands part of the bill.
Clause 18, cash monitoring.
Honorable Minister.
Thank you, Mr. Chair, that the bill be amended in clause 18(1)(b)(2) by deleting the words, quote, comma, managed, comma, monitored, end quote.
Question is that the amendment stands part of the clause. All those in favor, please say aye. Those against? The ayes have it. Question is now that clause 18 as amended stands part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clause 18 as amended stands part of the bill.
Clause 19, identification of securities. Clause 20, special measures. Clause 21, information required by the authority. Clause 22, authority may require information in respect of an alleged breach of Section 5. Clause 23, authority may take action in respect of unregistered private funds. Clause 24, authority to administer law. Clause 25, powers of authority in respect of a private fund. Clause 26, powers of authority, etc., to search in accordance with search warrant. Clause 27, authority shall not be hindered. Clause 28, appeals. Clause 29, obligation of auditor. Clause 30, exemption from compliance with trade and business licensing law.
Question is
Mr. Chairman,
the Leader of the Opposition.
during the debate, I made an intervention on clause 26, and I have not heard anything. Am I to assume that it was rejected?
Was
26, rejected.
that you had made an intervention, you had made,
So, for some clarification or response, and I haven't heard anything, so I'm just asking if it is assumed that it was rejected unceremoniously.
Honorable Minister, did you,
Mr. Chair, through you, yes, I would like to address the question that was raised by the member during his debate about whether it is necessary to include express reference to, I think, electronic or computer equipment when it comes to the issuance or the ability of SEMA to search a premises, I did have an offline discussion with the Attorney General, and I've asked him to address that particular concern as to whether or not there would be a need to have a committee stage amendment to address that, given that it's more of a law enforcement type of action.
Thank you, Chair. So, yes, the Honorable Minister did speak to me. We took a look at it again. The usual position, if I put it that way, is that the content of what goes into a warrant is done when the actual warrant itself is applied for. Sorry, so the legislation, Mr. Chair, is not usually not very specific about what goes into the warrant. So when the person applies to a justice of the peace or to a magistrate or something for a warrant, he will detail what it is that he's looking or searching for, and all of those will be written down in the warrant itself, and that would then enable the search and determine the validity of the warrant. So if the computer, laptop, cell phone is detailed in the warrant, then that enables the search to take place for those.
Mr. Chairman, with due respect, the focus of my concern, and I can leave it, wasn't about warrants. It was about listing how, what they can search for that is in the law, such as to search the premises and any person in the premises. If it is necessary, do so to break open and search anything on the premises in which a record may be stored or concealed, to take possession of and secure against interference any record that appears to indicate that any offense under this law has been, is being, or is about to be committed. And my intervention was on the basis that electronic devices and or computers were not listed as one of those things. And if there was objection, whether it was in warrant or not, if there was objection, the law would be contrary to the warrant, in the absence of electronic stuff. And certainly if the warrant says computers and the law say you're looking for this, I don't know how that would work. But the intervention wasn't about the warrants only. It was about what the law says the authority can do.
No, Mr. Chair, I don't think we're saying anything differently. The provision there sets out the broad enabling powers for searches by way of a warrant. The warrant itself lists what it is that you will be searching for. And so the warrant would normally says, included in the search, any laptop, computers, cell phones, all of these things. And then those would be covered by in a search warrant and would, of course, take care of any issue about invalidity of the warrant and so.
So, Mr. Chairman, I guess the Attorney General can explain to us, why do we list these then? If the warrant will cover all of those things, why do we list certain things?
Mr. Speaker, Mr. Chair, sorry. Yeah. Right. Enter the premises using force under search premises and a person premises if it's necessary to break, open, search anything on the premises in which a record may be stored or concealed. I am not so sure what else, this is a broad enumeration, Mr. Speaker, but it doesn't list the sort of thing that you would be looking for. So, in a particular part, you were asking about why is listed. And you're talking about C?
I guess they could break open the computer.
Mr. Speaker, if it might be helpful to point the member to the definition of record, as most of these provisions refer to record. In section 2 of the bill, record is defined as means any form in which information may be stored, so that may help to provide some clarity in that regard.
But, Mr. Speaker, yeah, thanks. But in any event, Mr. Speaker, as I said, the usual course is for the magistrate to list in the warrant itself, or the applicant to before the magistrate, to list or detail in the warrant itself what the warrant should cover. And that would then avoid any argument about the validity of the warrant. And so that's the usual thing.
Shall we move on?
Mr. Chairman, I'm fine. It's as long as they know my memory is like an elephant, eh? When they come back down here and say that they had difficulty with it, then I'll remind them.
So the question is that clauses 19 through to 30 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clauses 19 to 30 stands part of the bill.
Clause 31, regulations.
Honorable Minister.
Thank you, Mr. Chair, that the bill be amended in clause 31(1) as follows, by inserting after paragraph C the following paragraph, quote, D, exempting any person or class of persons or business or class of business from any provision of this law, semicolon, end quote, and by renumbering the remaining paragraphs.
Question is that the amendment do stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The question now is that clause 31 as amended stand part of the bill. All in favor?
Aye.
Those against? Clause 31 as amended now stands part of the bill.
Clause 32, amendment of schedule. Clause 33, savings, transitional, and consequential provisions.
Question is that clauses 32 and 33 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clauses 32 and 33 now stands part of the bill.
Schedule.
Schedule? Question is that the schedule do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The schedule stands part of the bill.
A bill for a law to provide for the registration of private funds and to provide for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The title stands part of the bill.
Mutual Funds Amendment Bill 2020. Clause 1, short titling commencement.
Question is that clause 1 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Short clause 1 stands part of the bill. One. You got some amendments. You got some amendments here.
Yeah, but I don't, start off with a general amendment. I don't know whether she will take that before we get into, I guess we should have done.
But she got a different title.
Yeah, but I guess you can move.
Mutual
that one
funds.
and that.
But not the same thing. Honorable members, in this bill you will find that some parts would be saying
Mutual funds law 2019.
Mutual Funds Law 2019 revision, and some might be saying 2020 revision. But we will take that as a part where the Attorney General will clean up. So we will move on with the bill.
Clause 2, amendment of section 2, definitions.
Honorable Minister, Clause 2.
Thank you, Mr. Chair. In accordance with the provisions of Standing Order 52-1 and 2, I, the Honorable Minister of Financial Services and Home Affairs, give notice to move the following amendments to the Mutual Funds Amendment Bill 2020. That the bill be amended in Clause 2 as follows, by deleting the word, quote, and, end quote, where it appears at the end of paragraph E, by deleting the full stop where it appears at the end of paragraph F and substituting the word, quote,
This is the cleanup.
semicolon, and, end quote, and after paragraph F by inserting the following paragraph, quote, G, in the definition of the words, quote, regulated mutual fund, end quote, comma, by deleting the words, quote, 4-1 or 4-3, end quote, and substituting the words, quote, section 4-1B, comma, 4-3, or 4-4A, end quote, period, end quote.
Clause 2. Question is that the amendment stand part of the clause. All in favor, please say aye.
Aye.
Those against, the ayes have it. The question now is that clause 2, as amended, stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clause 2 as amended stands part of the bill.
Clause 3, amendment of section 4, regulated mutual funds.
Honorable Minister.
That the bill be amended in clause 3 by deleting the word, quote, semicolon, and, end quote, where it appears at the end of paragraph B, and substituting a full stop, and by deleting paragraph C.
Question is that the amendment stands part of the clause. All in favor, please say aye.
Aye.
All against? The ayes have it. The amendment stands part of the clause. Question is that clause 3, as amended, stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The clause 3 as amended stands part of the bill.
Clause 4, amendment of section 5, mutual fund licenses.
Question is that clause 4 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clause 4 stands part of the bill.
Clause 5, amendment of section 8, annual audit of regulated mutual fund.
Honorable Minister.
Thank you, Mr. Chair, that the bill be amended in clause 5 as follows, by deleting paragraphs A, B, D, E, and F, and renumbering paragraph C and G as paragraphs A and B respectively. And in the renumbered paragraph A, in section 1A, by deleting the words, quote, or mutual fund registered under section 44A, end quote.
Question is that the amendments do stand part of the clause. All in favor?
Aye.
Those against? The ayes have it. The amendment stands part of the clause. The question now is that clause 5 as amended do stand part of the bill. All those in favor?
Aye.
Those against? The ayes have it. Clause 5 as amended stands part of the bill.
Clause 6, amendment of section 9, regulated mutual fund to pay annual fee.
Question is that clause 6 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clause 6 as amended. Clause 6 do stand part of the bill.
Clause 7, amendment of section 10, person to be authorized to administer mutual funds.
Honorable Minister?
That the bill be amended by deleting clause 7.
Question is that the amendment do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The amendment now stands part of the bill. Yes, clause 7 as amended stands part of the bill.
Clause 8, amendment of section 23, special audits of regulated mutual funds or regulated EU-connected funds.
Minister?
That the bill be amended by deleting clause 8.
The question is that amendment stands part of the clause. All those in favor, please say aye. Those against? The ayes have it. The amendment stands part of the clause. The question is now that clause 8 as amended stands part of the bill. All in favor, please say aye.
Aye.
Those against? The ayes have it. Clause 8 as amended stands part of the bill.
Clause 9, amendment of section 29, authority to administer law.
Question is that the Honorable Minister?
Thank you, Mr. Chair, that the bill be amended by deleting clause 9.
Question is that the amendments stand part of the clause. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clause 9 as amended stands part of the bill. The question is now that
Clause 9,
no, you go move to 10. Question is that clause 9 as amended do stand part of the bill. All in favor?
Aye.
Those against? Clause 9 as amended stands part of the bill.
Clause 10, amendment of section 30, powers of authority in respect of regulated mutual funds or regulated EU-connected funds. There's an amendment to that.
Honorable Minister?
Thank you, Mr. Chair, that the bill be amended by deleting clause 10 and substituting the following clause. Quote, amendment of section 30, powers of authority in respect of regulated mutual funds or regulated EU-connected funds. 10, the principal law is amended in section 30 as follows. In section 3, as follows. 1, in paragraph A, by deleting the words, quote, 4.1b or 4.3, end quote, and substituting the words, quote, section 4.1b, comma, 4.3 or 4.4a, end quote. And 2, in paragraph B, by deleting the words, quote, any mutual fund license the mutual fund holds, end quote, and substituting the words, quote, the mutual fund, end quote. And 3, in paragraph D, by deleting the words, quote, "the fund," end quote, and substituting the words, quote, "the mutual fund," end quote. And B, in section 16, by deleting the words, quote, "41B" or 43, end quote, and substituting the words, quote, "41B, comma, 43, or 44A," end quote, period.
That should be subsection 16.
In subsection 16, so
16.
B, I'll read that again. In subsection 16, by deleting the words, quote, "41B or 43, end quote, and substituting the words, quote, "41B, comma, 43, or 44A," end quote, period, end quote.
Substituting the words section 41B, 43, or 44A, am I right?
That's the substitution to
Question
be added.
is that the amendment do stand part of the clause. All those in favor, please say aye.
Aye.
Those against, the ayes have it, the amendment stands part of the clause. The question is now that clause 10, as amended, do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, clause 10 do now stand part of the bill.
Clause 11, amendment of section 32, authority may attend winding up proceedings.
Honorable Minister,
That the bill be amended by deleting clause 11.
question is that the amendment do stand part of the bill. All in favor?
Aye.
Those against? The ayes have it. Question is now that clause 11 stands amended. All in favor?
Aye.
Maybe a repetition, but I think that's what it is. Those against? Question, clause 11 as amended stands part of the bill. I didn't put that. I don't.
Clause 12, amendment of section 35, obligation of auditors. Amendment to that.
Honorable Minister,
Thank you, Mr. Chair, that the bill be amended by deleting clause 12 and substituting the following clause. Quote, amendment of section 35, obligation of auditors. 12, the principal law is amended in section 35 by repealing subsection 6, period, end quote.
question is that the clause, that the amendment stands part of the clause. All in favor, please say aye.
Aye.
Those against? The ayes have it, the amendment stands part of the clause. The question is that clause 12 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against? Clause 12 as amended stands part of the bill.
Clause 13, repeal of 37, indemnity. Clause 14, repeal of section 38, common law restriction on alienation clarified. Clause 15, savings and transitional.
Question is that clauses 13 through to 15 stands part of the bill. All in favor, please say aye.
Aye.
Those against? The ayes have it. Clauses 13, 14, and 15 stands part of the bill. Title?
A bill for a law to amend the mutual funds law 2020 revision to enhance the regulatory and supervisory framework for mutual funds and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The title stands part of the bill. You can do the third reading tomorrow, because they're not going to do suspension.
Right.
Okay. Let's do the, they can.
Monetary Authority Amendment Bill 2020, Clause 1, short title.
Club is the title, you read the title, and you read the
Sorry,
title and then the clause.
Clause 2, amendment of Section 2 of the Monetary Authority Law. Do you want to make her do this first? Because make her run this so that I can actually read this properly.
So,
Make her do the amendment.
Honorable Minister, you have an amendment?
Mr. Speaker, in accordance with the provisions of Standing Order 52.1 and 2, I, the Honorable Minister of Financial Services and Home Affairs, give notice to move the following amendments to the Monetary Authority Amendment Bill 2020, that the bill be amended by deleting the words, quote, Monetary Authority Law 2018 revision, end quote, wherever they appear, and substituting the words, quote, Monetary Authority Law 2020 revision, end quote.
Question is that the amendment do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The amendment stands part of the clause. The question now is that clause 3?
No, that's it.
I think we stop there.
That's getting confusing. I'll read clause 1 again.
Yeah.
Clause 1, short title. Clause 2, amendment of Section 2 of the Monetary Authority Law 2020 revision, definitions.
Honorable Minister?
No, take the vote on 1 and 2.
Oh, these bills?
Take the vote on 1 and 2. Yeah.
What's all this?
It's just 3 clauses.
No, I know there's 3 clauses. I'm looking at the bills. Question is that clauses 1 and 2 do stand part of the bill. All in favor, please say aye.
Aye.
Those against? The ayes have it. Clauses 1 and 2 stands part of the bill.
Clause 3, repeal and substitution of Section 3 of the Monetary Authority Law 2020 revision.
Honorable Minister?
Thank you, Mr. Chair. That the bill be amended in Clause 3 by deleting Schedule 3 and substituting the following in Schedule. Quote, Schedule 3, brackets, Section 2 and 4, brackets 4, close brackets, private sector associations. 1, Association of Legal Professionals and Advocates, Cayman Limited. 2, Blockchain Association of the Cayman Islands Limited. 3, Cayman Finance Limited. 4, Cayman International Reinsurance Companies Association. 5, Cayman Islands Fund Administrators Association. 6, Cayman Islands Institute of Professional Accountants. 7, Cayman Islands Insurance Association. 8, Cayman Islands Legal Practitioners Association Limited. 9, CFA Society Cayman Islands. 10, Insurance Managers Association of Cayman Limited. 11, Recovery and Insolvency Specialists Cayman Association Limited. 12, Society of Trust and Estate Practitioners Cayman Islands. 13, the Alternative Investment Management Association Limited. 14, the Cayman Islands Association of Financial Advisors. 15, the Cayman Islands Compliance Association Limited. 16, the Cayman Islands Bankers Association Limited. 17, the Cayman Islands Company Managers Association. 18, the Cayman Islands Directors Association Limited, end quote.
Question is that the amendment do stand part of the clause. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The amendment stands part of the clause. The question is that clause 3 as amended stand part of the bill. All those in favor?
Aye.
Those against? The ayes have it. Clause 3 as amended stands part of the bill.
A bill for a law to amend the Monetary Authority Law 2020 revision and to add the Private Funds Law 2020 to the list of regulatory laws, to update the list of private sector associations that the Cayman Islands Monetary Authority must consult under Section 4 of the Monetary Authority Law 2020 revision, and for incidental and connected purposes.
Title, right? Question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The title stands part of the bill.
Companies Amendment Bill 2020. Clause 1, short titling commencement. Clause 2, amendment of Section 2 of the Companies Law 2018, revision, definitions and interpretation. Clause 3, amendment of Section 40, register of members.
Don't we have assistant one? And the bill is amended, waiting in clause 3.
Where?
You got a different phone from me? Yeah.
Oh, yeah, no, it's companies, you're limited liability. Clause 3, amendment of Section 40, register of members. Clause 4, amendment of Section 244, interpretation. 1 to 4.
Question is that clauses 1 through to 4 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? Clauses 1 through to 4 stands part of the bill.
Clause 5, amendment of Section 245, application.
Honorable Minister.
Thank you, Mr. Chair. Mr. Chair, in accordance with provisions of Standing Order 52.1 and 2, I, the Honorable Minister for Financial Services and Home Affairs, give notice to move the following amendments to the Companies Amendment Bill 2020. That the bill be amended by deleting Clause 5 and substituting the following clause. Quote, amendment of Section 245 application. 5, the principal law is amended in Section 245(3)(a) by deleting the words, quote, in excess of 75%, end quote, and substituting the words, quote, 75% or more, end quote, period, end quote.
Question is that amendment stand part of the clause. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The amendment stands part of the clause. The question now is that clause 5 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clause 5 as amended stands part of the bill.
Clause 6, insertion of Section 245E, application of part in relation to investment funds.
Honorable Minister.
That the bill be amended by deleting Clause 6.
Question is that amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The amendment stands part of the clause. An abundance of caution. Question is that the clause be deleted. All in favor?
Aye.
Those against? The ayes have it. The clause is now deleted.
Clause 7, amendment of section 247, duty of companies to identify beneficial owners.
Honorable Minister,
Thank you, Mr. Chair, that the bill be amended by deleting Clause 7 and substituting the following clause. Quote, amendment of Section 247, duty of companies to identify beneficial owners. 7, the principal law is amended in Section 247(3) by deleting the words, quote, more than 25%, end quote, wherever they appear, and substituting the words, quote, 25% or more, end quote, period, end quote.
question is that the amendment do stand part of the clause. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The amendment stands part of the clause. The question is that clause 7 as amended stands part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clause 7 as amended stands part of the bill.
Clause 8, amendment of section 248, duty of companies to identify relevant legal entities.
3, it's about 9 and 10 in one. 8, 9, and 10. I think they're doing one time.
Clause 9, amendment of section 249, duty of companies to give notice to registrable persons. Clause 10, amendment of section 250, duty of beneficial owners and relevant legal entities to supply information.
Honorable Minister,
That the bill be amended by deleting clauses 8, 9, and 10.
question is that the amendment stands part of the bill. All in favor?
Aye.
Those against? The ayes have it. The question now is that clause 8, 9, and 10 is deleted from the bill. All in favor?
Aye.
Those against? The ayes have it. Clauses 8, 9, and 10 are deleted from the bill.
Clause 11, amendment of section 252, duty to establish and maintain beneficial ownership register.
Honorable Minister,
That the bill be amended by deleting clause 11 and substituting the following clause. Quote, amendment of section 252, duty to establish and maintain beneficial ownership register. 11, the principal law is amended in section 252 as follows. A, by repealing sections 2 and 3 and substituting the following subsections. Quote, 2, a corporate service provider engaged for the provision of registered office services by A, an exempted company, B, an ordinary non-resident company, or C, a company registered to carry on a special economic zone business in a special economic zone under the Special Economic Zones Law 2017 revision, comma, shall keep the beneficial ownership register of the company. 3, an ordinary resident company to which this part applies may engage the registrar to assist the company to establish and maintain its beneficial ownership register. 3A, where an ordinary resident company does not engage the registrar under subsection 3, the corporate service provider engaged by the ordinary resident company shall keep the beneficial ownership register of the ordinary resident company, period, end quote. And by inserting after subsection 4, 4, the following subsection. Quote, 5, in this section, quote, ordinary non-resident company, end quote, means a company designated by the financial secretary as a non-resident company in accordance with section 2.3 of the Local Companies Control Law 2019 revision, and, quote, ordinary resident company, end quote, means a company which carries on business in the islands in accordance with section 2.2 of the Local Companies Control Law 2019 revision, period, end quote, period, end quote.
Question is that the amendment stands part of the bill. All in favor?
Aye.
Those against? The ayes have it. The amendment stands part of the bill. The question now is that clauses 11 as amended stand part of the bill. All in favor?
Aye.
Those against? The ayes have it. The clause 11 as amended stands part of the bill.
Clause 12, amendment of section 253, role of corporate services provider and registrar.
Honorable Minister,
That the bill be amended by deleting clause 12.
question is that that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The amendment stands part of the clause. Question now is that the clause 12 be deleted. All in favor?
Aye.
Those against? The ayes have it, and clause 12 stands to be deleted.
Clause 13, amendment of section 262, limits on searches that may be executed.
Honorable Minister,
That the bill be amended in clause 13C in the proposed new subsection 3A by deleting the words, quote, or corporate services provider, end quote.
question is that the clause now, the amendment stands part of the clause. All those in favor?
Aye.
Those against? The ayes have it. The question now is that clause 13 as amended stands part of the bill. All those in favor?
Aye.
Those against? Clause 13 as amended stands part of the bill. Honorable Minister?
Not right. Clause 14, insertion of section 262A, beneficial ownership information in relation to investment funds.
Honorable Minister?
That the bill be amended by deleting clause 14.
Question is that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Question is now that the clause 14 be deleted. All in favor?
Aye.
Those against? The ayes have it. Clause 14 stands to be deleted.
Clause 15, amendment of section 277, unlawful search or disclosure of beneficial ownership information. Clause 16, insertion of 279A, request for additional information.
15 and 16. Question is that clauses 15 and 16 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clauses 15 and 14 do stand part of the bill. 15 and 16, that is. Do stand part of the bill. All in favor?
Aye.
Those against? The ayes have it. Clauses 15 and 16 stands part of the bill.
Clause 17, amendment of section 280, regulations.
Honorable Minister.
That the bill be amended by deleting clause 17.
Question is that amendment stands part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. The question is that clause 17 be deleted. All those in favor,
Aye.
those against, the ayes have it. Clause 17 stands to be deleted.
And she has a general one at the end. She can move that.
Honorable Minister.
That the bill be amended by deleting the words, quote, Companies Law 2018 revision, end quote, wherever they appear, and substituting the words, quote, Companies Law 2020 revision, end quote.
The question is that the amendment stands part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The amendment stands part of the bill.
A bill for a law to amend the Companies Law 2020 revision and to increase the effectiveness of the beneficial ownership regime and for incidental and connected purposes.
Question is that the title do stands part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The title stands part of the bill. Limited liabilities now. What's this one? Which one is that?
Limited companies.
Companies now, eh?
Limited liability companies.
Mhm. Partnership.
Limited Liability Companies Amendment Bill 2020, Clause 1, Short Title and Commencement. Clause 2, Amendment of Section 2 of the Limited Liability Companies Law 2018 Revision, Interpretation. 1 and 2.
Question is that clauses 1 and 2 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clauses 1 and 2 stands part of the bill.
Clause 3, Amendment of Section 71, Application.
Honorable Minister.
Thank you, Mr. Chair. Mr. Chair, in accordance with the provisions of Standing Order 52-1 and 2, I, the Honorable Minister responsible for Financial Services and Home Affairs, give notice to move the following amendments to the Limited Liability Companies Amendment Bill 2020. That the bill be amended by deleting Clause 3 and substituting the following clause, quote, Amendment of Section 71, Application. 3. The principal law is amended in Section 71, 3A by deleting the words, quote, in excess of 75%, end quote, and substituting the words, quote, 75% or more, end quote, period, end quote.
Question is that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The amendment stands part of the clause. The question now is that clause 3 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clause 3 as amended stand part of the bill.
Clause 4, insertion of Section 71A, application of part in relation to investment funds.
Honorable Minister.
That the bill be amended by deleting Clause 4.
Question is that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The amendment stands part of the clause. The question is that clause 4 be deleted. All those in favor, please say aye.
Aye.
Those against, the ayes have it, and clause 4 stands to be amended. Deleted.
Clause 5, amendment of Section 73, duty of limited liability companies to identify beneficial owners.
Honorable Minister.
That the bill be amended by deleting Clause 5 and substituting the following clause, quote, amendment of Section 73, duty of limited liability companies to identify beneficial owners. 5, the principal law is amended in Section 73(3) by deleting the words, quote, more than 25%, end quote, wherever they appear, and substituting the words, quote, 25% or more, end quote, period, end quote.
Question is that the amendment do stand part of the clause. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The amendment stands part of the clause. Question now is that clauses 5 as amended do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, clause 5 as amended stands part of the bill.
Clause 6, amendment of Section 74, duty of limited liability companies to identify relevant legal entities. Clause 7, amendment of Section 75, duty of limited liability companies to give notice to registrable persons. Clause 8, amendment of Section 76, duty of beneficial owners and relevant legal entities to supply information.
Honorable Minister,
That the bill be amended by deleting clauses 6, 7, and 8.
question is that the amendment do stand part of the bill, all those of the clause. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Question is that the clauses 6, 7, and 8 be deleted. All in favor, please say aye.
Aye.
Those against, the ayes have it. Clauses 6, 7, and 8 stands to be deleted.
Clause 9, repeal and substitution of Section 78, duty to establish and maintain beneficial ownership register.
Honorable Minister,
That the bill be amended by deleting Clause 9 and substituting the following clause, quote, repeal and substitution of Section 78, duty to establish and maintain beneficial ownership register. 9, the principal law is amended by repealing Section 78 and substituting the following section, quote, duty to establish and maintain beneficial ownership register. 78, a limited liability company to which this part applies shall keep its beneficial ownership register at the limited liability company's registered office, period, end quote, period, end quote.
question is that the amendment do stand part of the clause. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The amendment stands part of the clause. Question now is that clauses 9 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clause 9 as amended stands part of the bill.
Clause 10, amendment of Section 79, role of corporate services provider.
Honorable Minister,
That the bill be amended by deleting Clause 10.
question is that the amendment do stand part of the clause. All those in favor, please say aye.
Aye.
Those against, the ayes have it, and the amendment does stand part of the clause. The question is that clause 10 be deleted. All those in favor, please say aye.
Aye.
Those against, the ayes have it, and clause 10 stands to be deleted.
Clause 11, amendment of Section 88, limits on searches that may be executed.
Honorable Minister,
That the bill be amended in Clause 11B in the proposed new subsection 3 by deleting the words, quote, or corporate services provider, end quote.
question is that clause 7, the amendment do stands part of the bill, clause, do stands part of the clause. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The amendment stands part of the clause. The question is now that clause 11, is it 11B?
Just 11.
Yes, 11? Okay. The question is that clause 11 as amended do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it, and Clause 7 as amended stands part of the bill.
Clause 12, insertion of Section 88A, beneficial ownership information in relation to investment funds.
Honorable Minister,
That the bill be amended by deleting Clause 12.
question is that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clause 12 stands to be deleted.
Clause 13, insertion of Section 90A, request for additional information. Clause 14, amendment of Section 100, failure of a limited liability company to establish or maintain beneficial ownership register. Clause 15, amendment of Section 101, failure to comply with notices. Clause 16, amendment of Section 102, failure to provide information.
Question is that clauses 13, 14, 15, and 16 do stand part of the bill. All those in favor, stand part of the clause. All those in the bill. Let me take that again. Question is that clauses 13, 14, 15, and 16 do stand part of the bill. All those in favor?
Aye.
Those against? The ayes have it, and clauses 13 through to 16 stands part of the bill.
Clause 17, amendment of Section 106, regulations.
Honorable Minister,
That the bill be amended by deleting Clause 17.
question is that the amendment do stand part of the clause. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The amendment stands part of the clause. The question now is that clause 17 be deleted. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clause 17 stands to be deleted. Honorable Minister?
That the bill be amended by deleting the words, quote, Companies Law 2018 revision, end quote, wherever they appear, and substituting the words, quote, Companies Law 2020 revision, end quote. That the bill be amended by deleting the words, quote, Limited Liability Companies Law 2018 revision, wherever they appear, and substituting the words, quote, Limited Liability Companies Law 2020 revision, end quote.
Question is that these amendments do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The amendment stands part of the bill.
A bill for a law to amend the Limited Liability Companies Law 2020 revision to increase the effectiveness of the beneficial ownership regime and for incidental and connected purposes.
Question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The title do stands part of the bill. Which one?
Limited Liability Partnership.
The one?
Partnership.
That's this one.
Limited Liability Partnership Amendment Bill 2020. Clause 1, short title and commencement. Clause 2, amendment of Section 2 of the Limited Liability Partnership Law 2017, interpretation. Clause 3, amendment of Section 19, changes in registered particulars. Clause 4, insertion of Section 21A, licensing requirement. Clause 5, amendment of Section 31, strike off. Clause 6, amendment of Section 39, continuation from another jurisdiction to the islands. 1 to 6.
Question is that clauses 1 through to 6 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it, and clauses 1 through to 6 stands part of the bill.
Clause 7, amendment of section 52, application.
Honorable Minister.
Thank you, Mr. Chair. Mr. Chair, in accordance with the provisions of Standing Order 52.1 and 2, I, the Honorable Minister responsible for Financial Services and Home Affairs, give notice to move the following amendments to the Limited Liability Partnership Amendment Bill 2020. That the bill be amended by deleting Clause 7 and substituting the following clause. Quote, amendment of Section 52, application. 7, the principal law is amended in Section 52.4A by deleting the words, quote, in excess of 75%, end quote, and substituting the words, quote, 75% or more, end quote, period, end quote.
Question is that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The amendment stands part of the clause. Question now is that clause 7 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it, and clause 7 as amended stands part of the bill. You. 8, 9, 10, 11, 12.
Clause 8, insertion of section 52A, application of part in relation to investment fund. Clause 9, amendment of section 54, duty of limited liability partnerships to identify beneficial owners. Clause 10, amendment of section 55, duty of limited liability partnerships to identify relevant legal entities. Clause 11, amendment of section 56, duty of limited liability partnerships to give notice to registrable persons. Clause 12, amendment of section 57, duty of beneficial owners and relevant legal entities to supply information.
Honorable Minister.
That the bill be amended by deleting clauses 8, 9, 10, 11, and 12.
Question is that the amendments do stand part of the clauses. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Question is that the clauses 8, 9, 10, 11, and 12 is deleted. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clauses 8, 9, 10, 11, and 12 stands to be deleted.
Clause 13, repeal and substitution of section 59, duty to establish and maintain beneficial ownership register.
Honorable Minister.
Thank you, Mr. Chair, that the bill be amended by deleting clause 13 and substituting the following clause. Quote, repeal and substitution of section 59, duty to establish and maintain beneficial ownership register. 13, the principal law is amended by repealing section 59 and substituting the following section. Quote, duty to establish and maintain beneficial ownership register. 59, a limited liability partnership to which this part applies shall keep its beneficial ownership register at the Limited Liability Partnerships Registered Office, period, end quote, period, end quote.
Question is that the amendment do stand part of the clause. All those in favor, please say aye. Aye. Those against? The ayes have it. The amendment stands part of the clause. Question now is that clause 13 as amended stands part of the bill. All those in favor, please say aye. Aye.
Aye.
Those against, the ayes have it, and clause 13 as amended stands part of the bill.
Clause 14, amendment of section 69, limits on searches that may be executed.
Honorable Minister,
That the bill be amended in clause 14B in the proposed new subsection 3 by deleting the words, quote, "or corporate services provider," end quote.
question is that the amendment do stand part of the clause. All those in favor, please say aye.
Aye.
Those against, the ayes have it, the amendment stands part of the clause. The question now is that clause 14 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The clause 14 as amended stands part of the bill.
Clause 15, insertion of section 69A, beneficial ownership information in relation to investment funds.
Honorable Minister,
That the bill be amended by deleting clause 15.
question is that the amendment do stand part of the clause. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The question now is that clause 15 be deleted. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clause 15 stands to be deleted.
Clause 16, insertion of section 71A, request for additional information.
Question is that clause 16 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clause 16 stands part of the bill.
Clause 17, amendment of section 87, regulation under this part.
Honorable Minister,
That the bill be amended by deleting clause 17.
question is that the amendment stands part of the bill. The clause, all those in favor, please say aye.
Aye.
Those against, the ayes have it. The amendment stands part of the clause. The question now is that clause 17 stands to be deleted. All those in favor?
Aye.
Those against? The ayes have it. Clause 17 stands to be deleted. Yeah. Honorable Minister,
That the bill be amended by deleting the words, quote, "Companies Law 2018 revision," end quote, wherever they appear, and substituting the words, quote, "Companies Law 2020 revision," end quote.
question is that the amendment stands part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The amendment stands part of the bill.
A bill for a law to amend the Limited Liability Partnership Law 2017 to require limited liability partnerships to obtain a license to operate where applicable, to increase effectiveness of the beneficial ownership regime and for incidental and connected purposes.
Question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The title therefore stands part of the bill. Plenty. Premier, you must drink plenty black coffee.
You want to drink anything black and warm, you drink it.
Who says so? Yeah, how he want the female name of it? Minister? I don't got this one either. All this?
Tax information, the tax.
International Tax Cooperation Economic Substance Amendment Bill? I was identifying the bill to the minister.
Yes, sir, I was
Sorry.
The clerk will read it.
International Tax Cooperation Economic Substance Amendment Bill 2019.
Honorable Minister. I don't.
Yes, Mr. Chair, in accordance with the provisions of Standing Order 52-1 and 2, I, the Honorable Minister of Financial Services and Home Affairs, give notice to move the following amendments to the International Tax Cooperation Economic Substance Amendment Bill 2019. That the bill be amended as follows. By deleting the words, quote, International Tax Cooperation Economic Substance Law 2018, end quote, wherever they appear, and substituting the words, quote, International Tax Cooperation Economic Substance Law 2020 revision, end quote. By deleting the words, quote, Limited Liability Companies Law 2018 revision, end quote, wherever they appear, and substituting the words, quote, Limited Liability Companies Law 2020 revision, end quote, and by deleting the words, quote, Companies Law 2018 revision, end quote, wherever they appear, and substituting the words, Companies Law 2020 revision, end quote.
Which one is that?
That's the general one, so just, the question is that the amendments not
Question is that the amendments do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The amendment stands part of the bill.
Clause 1, short title. Clause 2, amendment of Section 4 of the International Tax Cooperation Economic Substance Law 2018.
Requirements.
2020, sorry. Requirement to satisfy economic substance tests. Clause 3, amendment of Section 5, guidance.
They have amendments? They have amendments? No. Question is that clauses 1, 2, and 3 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clauses 1, 2, and 3 stands part of the bill.
Clause 4, amendment of Section 7, requirement to provide information.
Honorable Minister.
That the bill be amended in Clause 4 by deleting paragraph A and substituting the following paragraph. Quote, A, by repealing subsection 1 and substituting the following paragraph. Quote, 1, an entity shall annually notify the authority of the following. A, whether or not it is carrying on a relevant activity. B, if it is carrying on a relevant activity, whether or not it is a relevant entity. C, in the case of an entity that is carrying on a relevant activity and is tax resident in a jurisdiction outside the islands, 1, the name and address of its immediate parent, ultimate and ultimate beneficial owner, and any other information reasonably required to identify its immediate parent, and ultimate beneficial owner. 2, the date of the end of its financial year. And 3, the jurisdiction in which the entity is claiming to be tax resident and whether any other, 3, the jurisdiction in which the entity is claiming to be tax resident and any other information as may reasonably be required to support that claim. D, in the case of a relevant entity that is carrying on a relevant activity, 1, the date of the end of its financial year, and 2, the name and address of the officer who is responsible for providing information to the authority, and shall provide appropriate evidence to support the information provided in the notification as may reasonably be required by the authority, period, end quote, semicolon, end quote. By deleting paragraph C and renumbering the subsequent paragraphs.
Question is that amendments do stand part of the clause. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The amendments do stand part of the clause. The question is now that clause 4 as amended do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clause 4 as amended stands part of the bill.
Clause 5, amendment of section 10, sharing of information.
Is it an amendment? Yes, sir. Is it an amendment? Yes, sir. Honorable Minister,
Thank you, Mr. Chair, that the bill be amended in Clause 5B by deleting subsection 3 and substituting the following subsection. Quote, 3, in the case of an entity that is carrying on a relevant activity and is tax resident in a jurisdiction outside of the islands, comma, the authority shall, comma, in accordance with relevant international standards and schedule agreements, comma, provide the information provided to it under this law, A, to the competent authority in the jurisdiction in which that entity is tax resident, B, to the competent authority in the jurisdiction in which the immediate parent, ultimate parent, and ultimate beneficial owner of the entity resides, and C, if the relevant entity is incorporated outside the islands, to the competent authority of the relevant jurisdiction in which the entity is incorporated, period, end quote.
question is that the amendments do stand part of the clause. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The amendments do stand part of the clause. The question now is that clause 5 as amended do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clause 5 as amended stands part of the bill.
Clause 6, insertion of section 13A, anti-avoidance.
Honorable Minister,
That the bill be amended by deleting Clause 6 and renumbering Clause 7 thereafter.
that's all.
Just delete it.
Is there a deletion or just an amendment?
No, just deletion.
Question is that the amendment do stands part of the clause. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The amendment stands part of the clause. The question now is that clause 6 be deleted. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clause 6 is therefore deleted, stands to be deleted.
Clause 7, amendment of schedule, construction of words and expressions.
Honorable Minister,
Thank you, Mr. Chair, that the bill be amended in Clause 7 by deleting paragraphs B, C, and D and substituting the following paragraphs. Quote, B, in the definition of the words consolidated financial statements, end quote, by deleting the word, quote, company, end quote, and C, by inserting in the appropriate alphabetical sequence the following definition. Quote, quote, immediate parent, end quote, in relation to an entity means a person that owns directly 25% or more of the ownership interest or voting rights in the entity, semicolon, end quote, semicolon. D, by deleting the definition of the words, quote, parent company, end quote, semicolon. E, in the definition of the words, quote, subsidiary company, end quote, by deleting the words, quote, parent company, end quote, and substituting the words, quote, immediate parent, end quote, semicolon. And F, in the definition of the words, quote, ultimate parent company, end quote, by deleting the words, quote, ultimate parent company, end quote, and substituting the words, quote, ultimate parent, end quote, period, end quote.
question is that the amendment do stand part of the clause. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The amendment stands part of the clause. Question now is that Clause 7 as amended do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clause 7 as amended therefore stands part of the bill.
A bill for a law to amend the International Tax Corporation Economic Substance Law 2020 revision to make changes to the economic substance notification requirement and the requirement to provide and share information and for incidental and connected purposes.
Question is that the title do stands part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The title do stand part of the bill.
She gave us this, but I not had no time to look at it. This is amendments to the health practice one, but I should just put out here. Cut your mic on.
Sir, you have passed out an amendment. You circulated an amendment. Is it circulated?
No, because we would have approved it.
I thought I had approved it earlier. That's the revised one? Okay, so, but you're waiting for this to be circulated then? And there are copies now?
Well, you know, it sounds like you mean it to me.
No, I have.
Am I sitting here? No, right, no sense.
We want to thank the staff.
Yes, Mr. Speaker, I certainly would like to thank the members of the Ministry of Financial Services and the relevant department teams for being here this hour and providing the great support that they have throughout this entire process.
Minister, I have in my hand, just to want some clarity in this matter, two amendments, sets of amendments, three now, which was approved. They were approved. One from the member from the North Side, that has been circulated from the 24th of January. And I had one set from the minister. As I understand it, that one that was said has been revised into this bigger one. And so this is the one that will be circulated.
Mr. Chair, if I could beg your indulgence, one more time. Obviously, it would be completely remiss of me if I didn't also acknowledge the hard work of the legislative drafting team who are still here with us during this committee stage process as well. So we want to thank them for their
Yes.
support in our bills.
Thank you very much. We're waiting to get those amendments, or can we move forward with it? This is what is it? Yeah, that's it. Yes. Let's get this copies of it. Yeah, 1 to 6 we can do. They don't have no amendments.
No, he got 4.
Oh, no, Mr. Miller has
And he deleting 4.
amendments for 4.
All right.
Honorable members, we are to get some amendments, but we can go ahead with some of the bill, so let's do that.
All right.
Health Practice Amendment and Validation Bill 2020. Clause 1, short title. Clause 2, interpretation. Clause 3, amendment of the Health Practice Law 2017 revision, deletion of chairman and substitution of chairperson.
Question is that clauses 1, 2, and 3 do stand part of the bill. All those in favor, please say aye. Those against? The ayes have it. Clauses 1, 2, and 3 do stand part of the bill. I have a proposed amendment or a set of amendments by the member for North Side. Where yours is down to 6?
He's
Yeah.
at 4 too.
So
First one is 4.
we can do 4, Mr. Miller. He has a clause 4.
Yes. Yeah, they both start with 4.
We still got to wait then.
They both saying the same thing.
Yeah. Yeah.
Talk to me.
Honorable members, you should have the latest revision of the amendments by the Honorable Minister. So, you have checked these? You have checked this? Okay. Honorable members, you should have your copies of the proposed amendments, and we'll call on the minister to move the first amendment, which is amendment to section 4. Honorable Minister.
Mr. Chair, in accordance with the provision of Standing Order 52.1.2, I gave notice.
No, Honorable Minister.
Clause 4, amendment
Not
of
your
section 2, definitions.
Yes, sir.
Honorable Minister.
Thank you, Mr. Chair. In accordance with the provisions of Standing Order 52.1 and 52.2, I gave notice to move the following amendments to the Health Practice Amendment and Validation Bill 2020, that the bill amended by deleting Clause 4.
Question is that Clause 4, that the amendment do stand part of the bill. All those in favor? Aye. Those against? The ayes have it. The amendment stands part of the clause. The question is now that Clause 4 be deleted. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clause 4 stands to be deleted. Honorable Minister.
Well, Mr. Miller.
Mr. Chairman, I think it is necessary for me to withdraw my amendment that asks that clause 4 be deleted.
You, honorable member and members, Mr. Miller have, I trust that you have that copy, clause, you have a set of amendments for deletion of 4, 7, 8, and 9. And you are seeking to withdraw that, Mr. Miller?
For 4, we'll deal with the other ones because I don't necessarily agree with this.
Okay. You're moving to withdraw Clause 4. Question is that Clause 4, the amendment as put forward by the member from North Side, Clause 4, be deleted. Sorry. Yeah, that's quite the same thing. Be withdrawn. All those in favor, please say aye. Those against? The ayes have it. The amendment as put forward by Mr. Miller has been withdrawn.
Clause 5, amendment of section 24A, institutional registration. Clause 6, amendment of section 27A, practicing license.
Question is that clause... Mr. Chairman, I have some questions on clause 5.
So we take one at a time then. Clause 5?
Yes.
Clause 5. Member from North Side.
Mr. Chairman, I raised some concerns about removing the cap, the 6-year cap on these health professionals. I wonder if the minister would consider removing the cap only for board-certified specialist doctors, because I really can't support removing the cap for medical technicians, pharmacy technicians, practical nurses. All of these people are benefiting from the same thing. Yes, but these people came in through a different route, Mr. Premier. These people did not meet the qualifications by which the others came in, the high standards that we had.
Wait, this?
No, we're not. Oh, and trust me, the other ones that listed that board certified under the original regulation are specialists too. That's fine. Question is to the minister then, if my memory serves me correctly, the first license for institutional practitioners would have been issued in 2013. And it had a cap of 6 years. How many health professionals currently working at Health City are not licensed because the 6-year cap occurred in the latter part of 2019 or in January 2020?
Member has posed the question, is what you're doing. Member has posed the question.
Says it's an emergency.
No, he says there are emerging ones next week. I think it's reasonable. Huh?
Honorable Minister.
Mr. Chair, as of now, as we speak, there are none, but as I understand it, but within 1 hour and 16 minutes, there will be 9.
Can the minister confirm that that includes all the health nurses and all the other professionals working at Health City?
That's nurses. 9 tomorrow.
So there are no doctors who are affected by the cap, which would have gone out in late 2019.
Mr. Chair, Mr. Chair, some had expired last year in 2019, but we rectify it by using the law and not the regulations to extend it to January.
Could the minister, for my own edification, tell me what section of the law allowed you to extend the license? Because that cap is in the law, you know, not in the regulation.
Mr. Chairman, in the interim, these, and I know the Premier may recall this, that when he and I fought for these exact things to happen in committees, meaning select committees. These are issues that hopefully one day when this House become autonomous, we will restructure the regime and do committees to address these national issues in a bipartisan way, in order that when we reach here, we are okay with it.
Mr. Chair, it's Regulation 7 and 20, and the law it's 27A2.
Seven deals with qualifications, not length of license, or at least the health practice regulations 2013 that I have. And you say 24, what of the law?
Mr. Chair, 27A2.
And I'm trying to be extremely difficult, and I just want to make sure we try and get this thing right. I don't have a problem, as I asked you, if you would consider doing it only for the specialist board certified doctors. But I can't support you doing this for nurses and lab techs and everybody else. Because there came manual nurses who can apply for jobs up there.
Mr. Chairman, I don't know how many times I have to say this. This is an anomalous piece of legislation. It is the only piece of legislation which, as far as I know, seeks to limit the length that anyone can work in the Cayman Islands who are subject to the legislation. In every other respect, whether you are dealing with a gardener, a farmer, a helper, they all have 9 years. They are subject to the provisions of the immigration law. The reasons which were initially contemplated that drove this limit no longer exist from this government's perspective. And all this provision is seeking to do is to put the people who work at Health City, the preeminent medical facility in the entire region, of increasing international stature and prominence, which provides top quality tertiary medical care for Caymanians and people across the region. To put those people in exactly the same position as everybody else who works in Cayman and requires a work permit or some similar permission to work. In other words, the expatriate population who work here. That's all this is seeking to do. It's not giving them any other benefit. They can't stay beyond the 9 years that the immigration law provides us. All this is seeking to do. And for the life of me, I cannot understand why we have this obsession, this prejudice against Indians, when And anybody else who works anywhere else, let alone in the private practices that exist and the other hospitals in Cayman, are not subject to such a restriction. I cannot for the life of me understand it. What is it that we have against Indians?
Mr. Chairman, I accept the Premier's concern about Indians. I have no such concern. I'm only concerned with the registration process. And these people are different from the other health practices who are licensed under the law. We created a special dispensation that was lower standards than the other ones. The other people in the private, it is lower. Okay. But what?
Mr. Chairman, this is the prejudice I speak about.
Honorable members, I don't think we should go down that road, because that's really not the subject of these amendments. And I'm addressing the member from the north side, because I don't think so. When you I don't.
Mr. Speaker, the allegation, the assertion by the member from Northside ought to be withdrawn. He has just claimed that the preeminent tertiary healthcare institution in the region has lower standards for its doctors and other ancillary staff than those which exist in other hospitals and practices in Cayman. It is patently untrue. I want to know where else in the region can doctors perform heart transplants. I wonder which other doctor working anywhere else. And my sister is the head of accident emergency at HSA, so people understand that I am not being blinded by anything on that end either. Where else in the region do you have doctors who can perform such high-level tertiary care? People come from all over the region and indeed from all over the world now for the benefit of this, and we have a member of this House asserting that it is a substandard institution. Mr. Speaker, it ought to be withdrawn and the member ought to apologize.
Mr. Chairman, I am extremely grateful that the Premier qualified his position on prejudice against Health City, because that I am not. In the absence of proper explanation when this thing was introduced here is why we're where we're at now. No one could explain or did explain where we were going with this. Granted, the Premier was not in the room at the time, who always has a handle on these things. And yes, I admit that maybe we should have seen through it from his position, but nobody explained the intricate details of it as well as he just did. Maybe the blame needs to lie squarely on the shoulders of the minister, but be that as it may, let that ride how that may as well.
Can't this ride like that, Mr. Chair?
But
what blame are we talking about?
Well, I am talking about the blame of not explaining this thing
Honorable
properly.
members, though, I mean, it is late in the night. It is late in the night for us to be going down that road, because I don't know. I thought the purpose of legislation was to explain what the legislation was before us. Did somebody had to get up to say that this is about an Indian doctor or a registration for Health City?
No, Mr. Chairman. I I trust that that was not the understanding about, I did not bring in anything about nationality or otherwise. I am talking about the specific reasons why we feel like this thing had to be corrected. The Premier did a wonderful job of explaining it. I am saying the Minister did not do that in his introduction. Now, the word blame I may have to withdraw, but certainly the responsibility lies on the person who's introducing any bill in these hallowed halls to ensure that it's understood by all members. That is where the responsibility lies. And I didn't get that. I honestly did not get it, and it may be said that I should have seen through it. Well,
While you explained it.
I may be short-sighted too, so we must explain these things when they come here. There's no need to be afraid of the truth.
That's why you had to explain it.
Mr. Chairman, the only thing I'm going to say is I wish that the member from West Bay North, is it?
Who?
Mr. Bernie Bush?
Yes.
I wish he was here, so he could pay, so he could explain, as he has to many people, and give thanks for how the unqualified doctors at Health City or at substandard levels saved his life from a heart attack.
No, I never said that when they do have anxiety.
Mr. Chairman, this is not about me playing rough. But Mr. Chairman, I have a simple question. If these people are equally qualified, are more qualified than all the other people who registered under Health Practitioners Councils, why are they confined to one institution?
Mr. Speaker, let me see if I can address that. Mr. Speaker, the current law and the law which existed, the health practice law that existed, or I can't even know if that was the correct name, but the name was used at the time, it's a long time ago now. You were leader of government business at the time, Mr. Speaker, Mr. Chairman. Limits who can practice generally in Cayman to 7 jurisdictions. I can't know if I can remember all of them off the top of my head because I've not been health minister for a while, but it was Jamaica, the United Kingdom, Australia, Canada, US, and I don't remember where else.
British Isles, I believe.
India is a huge country with a massive population. It does not have a unified system of doctor or medical personnel qualification. They are at differing standards and degrees. I know this because Dr. Shetty was at pains to explain this to me and others years and years ago. And so I wasn't in government at the time. I was in the House, but not in government, was in opposition. But it was not deemed possible to be able to simply include India in the list of countries because of the differing standards and various institutions across the various states that make up India. And so those who were advising at the time, and I was not there, so I'm speaking based on what I've been told, decided that they had to create a separate category of registration for Indian doctors to be able to operate in Cayman. Otherwise, they would have to go through an accreditation process in Jamaica or somewhere else. And the way that the Health City is structured with a rolling roster of personnel. The top doctors stay for longer periods, which is what we're dealing with, but and because this was part of not a standalone institution, but part of the bigger, I can't pronounce Dr. Shetty's hospital name, I won't try, but the of that this would work. I wasn't party to any of those discussions or intricate details. I only had the briefings as the now leader of the opposition did when we were in the opposition from Dr. Shetty. He must have 5 or 6 of them over the time that this concept was being developed. But I was here when the debates were had about this. I know the member from Northside has never supported it, ever, 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 and his position remains. Notwithstanding the overwhelming evidence that this is a top quality institution. But he's entitled to his own view. But, Mr. Chairman, I just think it's wrong to condemn and to put at a lower level the institution and the great work that the doctors and other personnel there continue to do. That's the best I can do in terms of explaining it.
We're going to move on to the amendments. What about it?
Mr. Chairman, I just want to thank the Premier and for his attempt to explain this entire thing. I don't want anyone to leave here or believe that I object to this bill because of the hospital.
You have made yourself clear on that several times, Honorable Member.
No, this is the first time.
No, you have said so before.
You mean your memory better than mine?
Yeah, but right now it's better than mine, very clear.
All right, Mr. Chairman, I shall acquiesce to your memory, but I just don't want that to be left out there. There were other issues with this bill that I had concern with the chief medical officer as well, being on that board and whatnot. I had real concerns about it.
Okay, I think, as I said, we need to move on with the amendments. Question is at 5 and 6. Sounds part of it. Question is that clauses 5 and 6 stands part of the bill. All those in favor, please say aye. Those against? The ayes have it. Clauses 5 and 6 stands part of the bill.
Clause 7, amendment of Schedule 1, Health Practice Commission.
Clause the Minister.
Yes, sir.
Honorable Minister. Second 7.
No, that's what I'm telling you, but they shouldn't have did it that way.
Mr. Chair, I move
Let's see what it says then.
an amendment to, I move to withdraw the original Clause 7 amendment
This one.
that was circulated,
This one.
Clause 7.
The minister earlier submitted a set of amendments, and he's seeking to withdraw that because those amendments have been superseded by the one just presented. The question is that we allow the minister to withdraw the first amendments. All in favor?
Aye.
Those against? The ayes have it. Those amendments are withdrawn, and we are dealing with the last set as put forward. The minister still has to move.
Mr. Chairman, I think it is necessary for me to withdraw my amendment to delete clause 7, 8, and 9, since the minister is doing that.
Yes. You want to move your amendment, Honorable Member?
Yeah, I move to withdraw my amendment to delete clauses 7, 8, and 9.
Question is that the member from Northside be allowed to withdraw the set of amendments that he put forward. The deletion of clause 7, the deletion of clause 8, the deletion of clause 9. All in favor? Those against? The ayes have it. The member amendments has been withdrawn. What we are dealing with now is the last set of amendments as put forward by the minister.
No, you,
Honorable Minister?
7. You needed 7.
In accordance with the provision of Standing Order 52-1 and 2, that the bill be amended, deleting clause 7, 8, and 9, and substituting the following clauses. Validation.
Delete 7. Just deal with 7. Delete 7. Just move 7.
That the bill be amended by deleting clause 7.
Question is that the amendment stands part of the clause. All those in favor, please say aye. Those against? The ayes have it. The question now is that clause 7 be deleted. All those in favor, please say aye.
Chairman, Mr. Chairman,
Yes.
just on the procedure, I think the minister is moving to delete the clause and substitute a new clause.
Not 7.
So I think that's what his motion needs to be, not just to delete the clause.
Not 7.
What is this? Validation is not 7? Validation
We
is
just
what?
deleting 7, right? No, he's substituting an 8 and a 9. Number, if you look at the heading and look at the clauses, they didn't do this right. Lee Grafton didn't do it right. He's just deleting 7 and he's substituting 8 and 9. Which, when we do the amendment, will be 7. I know what I'm doing, you know.
Yeah, I don't see them. I see them got 7 and 8. What
That's
is that?
because this should be 8. They're anticipating.
Yeah.
You see here, look. This is 8. Validation is 8. Immunity is 9. They can't. They're not. They shouldn't have changed it because they're anticipating something.
So they should be really not 7 but 8.
It should be 8 and 9.
Yeah, 9.
Right.
As I see it, Honorable Minister, you have sought to delete clause 7, and you have
You just deleting 8, 7.
and you have 8 and 9. 8 and 9. On this there is no clause 7. So it must be that he deleting 7.
Yes, that's what I'm trying to him to verify.
But
The same people that they commit malpractice up there on
7. He deleting 7.
and now they're still keeping more cases. You know what it means. Make the thing at me. And you know, you're a bad boy. You're too old for that now.
ay, ay, ay.
Is he deleting 7? Yeah, but I know that.
So why you take out 8? So why you take out 9? 9 is not part of the
What? He's deleting the whole 7, right? And he's substituting 8. What exists now as 8? And he's substituting what exists now as 9. Yes, once all of this amendments take place. Yes, but the way this is drafted, it's in anticipation of things happening that hasn't happened. I know that.
Honorable members, the minister moved the deletion of clause 7, and I think I put the question that the amendment stands part of the clause and that the clause 7 be deleted. And I'll ask for the vote again on that. All in favor, please say aye. Those against? Those against? The ayes have it. Clause 7 stands to be deleted.
That's right, that's all you're gonna do, but he can do that.
There, when we begin committees, we always say we give certain leeway to the Attorney General to do certain things. I would think those things are what we're talking about. Renumbering, etc.
So now he just got read from validation.
Thanks.
7.
We ready?
Right. And substituting the following clauses for those 3. That's it, 7 and 8. You mean tell me San can't count over 6?
You ready, sir?
Clause 8, validation.
No, we move amendment.
Honorable Minister,
So, Chair, the bill be amended by deleting clause 8.
And substituting.
and substituting, you got to read this full one now. This full one, Julie.
And substituting the following clauses.
Yes. 8. Validation.
Validation.
Yes.
But
So you read.
Clause 7:1, the purpose of the section is to remedy a defect in Regulation 7 of the Health Practice Registration
Yeah.
Amendment Regulations 2013, which was purported to be made in accordance with the Health Practice Law 2005 revision, the effect of which was to reduce in some instances, the 2-year period for practicing license provided for under the Health Practice Law 2005 revision. 2, the defect under subsection 1 made regulation 7 of the Health Practice Registration Amendment Regulations 2013 inconsistent with the Health Practice Law 2005 revision. 3, notwithstanding the inconsistency referred to under subsection 2, practicing licenses issued to institutionally registered practitioners during the specified period are validated and deemed to have been issued and expired in accordance with the Health Practice Law 2005 revision and any amendments to that law prior to the commencement of this law.
Mr. Chairman.
The member from Northside?
Yeah. I wonder if I could draw the minister's attention. I think he has the regulation wrong. Regulation 7 in the Health Practice Regulations Amendment, Regulations 2013, deals only with educational institutions, etc. It is Regulation 9, which is numbered as 7, but it is Regulation 9, not 7, that needs to be amended. No. It's important, right?
It's understood that the 7 should be 9.
Agreed.
I think members understand that. Now, the question is that the amendment stands part of the clause. All those in favor, please say aye. Those against?
No.
The ayes have it. The ayes have it. The amendment stands part of the clause. The question now is that clause 8, as amended, stand part of the bill. I'm going to say clause 8, and if it's different, if it's a clause 7, then we'll leave the Attorney General to clean that up. But from my counting here with amendments is clause 8. I'll repeat that. The question is that clause 8 as amended stand part of the bill. All those in favor, please say aye. Those against? The ayes have it. Clause 8 as amended stands part of the bill.
Clause 9, immunity from suit.
The member from Georgetown, can we have it read first? The minister?
Mr. Chair, that the bill be amended by deleting clause 9 and substituting the following clauses: immunity. 8.1, notwithstanding any law to the contrary, an act done by an institutionally registered practitioner during the specified period is deemed to be lawful and valid if the act would have been lawful and valid had the practicing license been issued in accordance with the Health Practice Law, with A, the Health Practice Law 2005 revision, and B, any amendments to the Health Practice Law 2005 revision prior to the commencement of this law. 2, for the purposes of subsection 1, an act done by an institutionally registered practitioner during the specified period is not lawful or valid if the act was negligent or done in bad faith.
Question is that the amendment do stand part of the clause. The member from Georgetown Central.
Thank you, Mr. Chair. I'm just drawing a point of concern, if you would allow, in the last vote, for Hansard purposes, it was said that, just allow the AG to clear up that. It was suggested that, the AG knows what's going on, so he can clear up the concern that was ambiguous just now. I am a bit concerned about the Hansard records not knowing, and it has to be clear as to if there's any discrepancies in the future. The records of this Honorable House is what will be referred to, not the Attorney General's mind. So he may know what's going on, but if it's not clear coming through this mic in respect to the Hansards, particularly for me, if I go, okay, let me double check and make sure that that went the way it's supposed to go, then saying that the AG will address it by way of correction of numbers and alignment, it has to be clear through the records of this House. And I'm just not trying to make a criticism, I'm just saying I want to make sure that it's clear what amendments is where, what their numberings are, so that we're dealing with legislation and law that can make major changes to people's lives. So to be mindful that if there's a challenge by saying what needs to be changed and what shouldn't be changed, that we're not just leaving it to the Attorney General's mind, which I know is pretty good all the same.
When we begin committee, and this is not something that happened now, as long as I've been coming to this Legislative Assembly, and I came here at least 8 years before I was elected, and I've been here 35 years, this has been the process. The process before you start any committee, it is said by the chairman, with the leave of the House, may we assume that as usual, we should authorize the Honorable Attorney General to correct minor errors and such the like in these bills. That is understood, that renumbering exercises, etc., is taken to that. And I don't think, and the Attorney General want to speak for himself, but I don't think that he's going to do that without checking the full record. Because it's not just renumbering, it could be other things. But we do leave it to them, and him and his department, I would think, do that. I understand the member's concern that you want everything to be correct, but that's what we're doing, though, you know. And we just can't deal with every minute aspect. When we have said we have given permission as a House to the Attorney General to look after those little items. I admit that it has been somewhat confusing, but I think we got that straightened out before before the minister went on to deal with his substantive amendments.
Mr. Chair.
And we've come to the end of those substantive amendments. Clark.
Mr. Chair.
The member from Georgetown Central.
Thank you, Mr. Chair. I just want to add to make sure that it's clear that by all means I'm not trying to undermine the AG in his goodwill and abilities. It's important that we also know that the people of this country is watching these proceedings, and they have to be felt ensured that these things are done right. And I didn't know about that provision before, so I appreciate you giving me the edification process of that, but I don't want to undermine the AG in any way, but it's important that these things are clear, and you rectified that, so thank you.
Put my wig on. That has been done.
You haven't taken it?
No. So, the question is then that the clause, let me repeat that. The question now is that clause 9, as amended, stand part of the bill. We did. All in favor?
The AG documents.
Yes. Just so that there is some clarity in more clarity in what we're doing. We are dealing with the clause immunity from suit. And let's make sure that this is straight. We have voted on the amended clause standing part of the bill. The question is now that the clause as amended stands part of the bill. I think we're repeating it, but all in favor? Those against?
Oh.
The ayes have it. Clause as amended stands part of the bill. Amendment. Yeah.
A bill for a law to amend the health practice law 2017 revision to distinguish between practicing licenses issued to fully registered practitioners and practicing licenses issued to institutionally and provisionally registered practitioners, to validate the health practice registration amendment regulation 2013 and the practicing licenses issued under the regulations and for incidental and connected purposes.
Question is that the title do stand part of the bill. All those in favor, please say aye. Those against? The ayes have it. The title do stand part of the bill. This concludes our business in committee. We go back, and since the House is meeting tomorrow morning, we shall do the reports at that time and the third readings at that time. The question is now, though, that the bills be reported to the House. All in favor? Those against? The ayes have it. The bills will be reported tomorrow morning at 10 a.m. if that's when the Attorney General says. Please be seated. The Honorable the Premier. 10 a.m. tomorrow.
Mr. Speaker, I know I stated my intent to complete government business today, but it truly would be cruel and unusual punishment to press on after 11:25 p.m.
You understand that word?
And Mr. Speaker, I would hate that any of us became ill and had to wind up at Health City. So, and so, Mr. Speaker, if the Leader of the Opposition will permit me, I would like to move the adjournment of this Honorable House until 10 a.m. tomorrow morning.
Question is that this Honorable Legislative Assembly do adjourn until 10 a.m. tomorrow morning. All in favor? Those against?
No. No.
The ayes have it.
Mr. Speaker,